sons and daughters are there, so it would go to all. My claim was that it would exclusively come to
48.
48 and
48 I've already heard.
yes.
तो ये ऐसे क्यों लगा?
Because your lordship had, my one argument was that certain daughters were not impleaded as parties, therefore your lordship had allowed me some time to implead them. Now the appellant's contention is that because he is denying the entire right of the other side, therefore
They are not missing.
so your lordship may dispose it of on merit. It can be taken up any time your lordship.
48 को कल
हाँ, ठीक है।
थोड़ा देखेंगे.
हाँ ठीक है ठीक है. और 49 में your lordship
48 is order 41 ruling है.
yes.
तब तो इसको कर सकते हैं सेकंड हाफ में.
हाँ हाँ ज़्यादा कुछ नहीं है.
इसको कल कर दीजिए सब. ठीक.
There is one Supreme Court judgment against me which
आप प्रोवाइड कर दीजिए.
and 49 your lordship, in delivery of possession deed has been already issued. It is IA is already there, but it has not been admitted because it has not been admitted. And the earlier round of proceeding, the second appeal was already admitted, but during the course of hearing, it was found out that one of the respondent had died when the matter was pending before the first appellate court. Therefore, with that liberty, the matter was disposed of. Then we substituted, and thereafter the same order is under challenge.
Okay. Now, earlier there was already a substantial question of law.
And substantial question of law.
Order?
Yes, and substantial question of law was whether the right of easement is applicable in the state of Jharkhand. And similar, there is a
right of easement is not applicable in the state of Jharkhand.
My contention is that it is not applicable, and in identical case, the Supreme Court has held with regard to state of Assam that if the Easement Act is not applicable, the court has no power to implement the provisions of Easement Act because that is a power which is exclusively vested with the legislature. That is the ground.
सभा 2 बजे आई.
हाँ.
अदर साइड तो है नहीं.
नहीं तो इसी के लिए because this would affect
वो
many
order
other
लेके
cases.
आएंगे. Order लेके आएंगे.
हाँ ठीक है.
तो previous इस सेकंड अपील का नंबर दीजिए ना, हम लोग रिकॉर्ड.
हम दे रहे हैं सब भी दे.
49.
हाँ 49.
49 राइट. 48 टुमारो. हम देखेंगे क्या है.
ठीक है ठीक.
हो सकता है आपको थोड़ा सुने भी आपको याद
हाँ
नहीं.
ठीक है ठीक.
It will be heard today because one similar matter, second appeal, 1/3/2023 already admitted. All the parties are same, arising out of same judgment also. All the parties are the same.
Where is that order? आप आइए सवा 2 बजे. ये 47 है आपका. 46. ठीक है. 46 एंड 49 ये दोनों सेकंड हाफ में हैं और 48 जो है इसका फाइल भी निकाल लेंगे. 48 कर देंगे. चलिए.
From daily Saturn 1, second appeal 23 of 1999.
टाइम के अलावा क्या चाहिए?
That is part 130. I have only making of the
सॉफ्ट कॉपी आपको मिला है ना?
no.
नो मतलब
So I have only
टाइम लेने के लिए कितना आप लोगों को एडवांस नोटिस दिए हैं टाइम लेने के लिए? इनका तो टाइम में से हम परेशान हैं. या आप तो आपको नहीं पता है कोई एडवांस नोटिस आया है इसमें? हाँ नहीं बता पाते मतलब?
first time
बहुत अच्छा काम कर रहे हैं. पहली बार आपने 99 के केस.
notice have been received.
बहुत
He
बहुत
gave me
खुशी
last week.
बहुत खुशी की बात है.
Sorry.
नोटिस आपको मिल गया है तो आप समझ लीजिए आप जीत ही गए. पुलिस स्टेशन से आपको नोटिस जाता है तब तो आप एपियर होते हैं. कब करेंगे?
Thursday.
आज इनको सुनते हैं. पाठन करके रखें. अब बैठिए. मेमो ऑफ अपील है ना आपके पास?
Judgment is not.
बहुत अच्छी बात. जजमेंट भी नहीं है. क्या है आपके पास?
Only I received one.
कोई बात नहीं. बैठिए. चलिए बैठिए.
The second appeal has been directed against the order, judgment and decree of affirmance, whereunder the suit brought by the plaintiff, who is the appellant before your lordship, has been partly allowed. Now, as a matter of fact, the plaintiff prayed for 3 reliefs. Relief number 1 related to the
Three reliefs, right?
3.
Just
Page 6 of the
flip निकाल लो. इसको निकाल लो.
first.
Yes.
Page 6 of the claim, ma'am, the 3 reliefs which were prayed for are as well. On adjudication, it may kindly be declared that the plaintiff is the owner of the premises in the suit. The defendants be ordered not to interfere with the possession of the property. Second, the deed of gift number 13959 dated 5/12/86 registered at Girirdi District Sub-Registration Office be declared null and void and not binding on the plaintiff. Third, defendant number 3 be directed to hand over the vacant possession of the room in her occupation, or in case of her default to do so, the same be done through the process of the court. Prayer 2 and 3 were rejected. Prayer number 1 was partly allowed in as much as the suit land which measures 7 decimals, 3.5 decimals was declared to be under the ownership of the plaintiff and 3.5 under the defendants. Against that, first appeal was moved. First appellate court was pleased to affirm the judgment and decree passed by the trial, and thus this second appeal. The same has been admitted on 18/7/2011, whereby the substantial question of law as framed reads as under: whether or not, in view of the facts concurrently found by the courts below, it follows that the deed of gift is null and void. And further, the liberty has been granted to raise any further substantial question of law. But if I may be permitted to start my argument preliminarily, and thereafter I would, with the leave of the Honorable Court, I would propose one more substantial motion.
Where is the proposal? You have to file an interlocutory application for that.
I'm aware of that.
So where is that?
I will file it.
When will you file it? After the judgment? आज ही
But आज होगा नहीं, the reason being that it has been listed today, so it is not possible. कल ही करना.
नहीं possible है तो हम आपके साथ additional substantial question of law नहीं सुनेंगे.
Therefore,
There is a procedure prescribed under law. The other side has to be given an opportunity.
Therefore,
That proposal has to come through and through a petition.
my lord.
Then
Therefore, I am praying that I may be permitted to file it tomorrow. I will serve a copy beforehand to the
तो
respondent.
आज क्या हम लोग टाइम पास कर रहे हैं?
हम preliminary बहस कर दे रहे हैं.
प्रिलिमिनरी क्यों बहस करेंगे? जब आपको एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाना है तो फिर क्या आप प्रिलिमिनरी?
Actually, ये इसी से निकल के ही आएगा जो फ्रेम है ऑलरेडी.
Sir, we will not permit this. You want to argue, you argue.
Okay, then I'll argue the case. If my lord so pleases, then it may be framed. If my lord so pleases, subject to kind consideration.
We will not frame it so modo like
My lord,
this.
because the perversity is there itself. I will try to satisfy you. I will try to satisfy.
इतना लेजरली कोर्ट आवर्स को मत लीजिए, ठीक है, कि आज करेंगे, कल आइए फाइल करेंगे, परसों वो बहस करेंगे। ये क्या ड्राइंग रूम डिस्कशन है क्या?
Saying that, my lord, just while going through the brief properly, my lord, I found that it is required to be framed.
ऐसे नहीं
So the case was,
नहीं नहीं, ऐसे हम सुनेंगे नहीं, आपका कुछ भी सुनेंगे।
madam, I will argue on this point only, sir.
दिस पॉइंट ओनली, दैट इज ऑल। आई विल नॉट परमिट फर्दर आर्गुमेंट। ये नहीं कि आप पाठड़ हो जाए उसके बाद आप एक आगे फाइल कर दीजिए, वो हम नहीं परमिट करेंगे। You should have been ready. Last time आपको सुन के नोटिस किए थे, क्या कर रहे थे?
Perversity flows from that itself.
Maybe perversity flows, we do not know. We are only concerned with the substantial question of law as framed. And if you wanted to exercise that liberty, then you should have taken appropriate steps at appropriate point of time.
I bow down on that, my lord, because that has not been taken earlier. Yes.
Don't take the court for granted, okay? यहाँ ड्राइंग रूम डिस्कशन नहीं चलता है। Hearing commence करने के बाद in the midst of the hearing you will file something. That is not permissible. Second appeal number 23 of 1999. The learned counsel for the respondent. Respondent number?
3.
Respondent number 3.
Substituted.
Substituted respondent number 3. Your file Pakalat number
Yes, yes.
has entered appearance. He prays for some time to prepare himself. He submits that the matter will be posted on Thursday. आप इनसे सॉफ्ट कॉपी ले लीजिए, अपनी पेन ड्राइव लेके आइए, अपना सॉफ्ट कॉपी ले लीजिए, और आपको चाहिए तो आप भी ले लीजिए। Counsel for the appellant has no objection for the prayer or adjournment. Post this case on Thursday in the supplementary list. No adjournment will be granted on the next day. किसका आइडिया?
For
इसीलिए एजेंट कर दिया, आपको जो करना है आप करिए। हियरिंग नहीं शुरू किए हैं, लेकिन आपका वो जो आप मेंशन कर रहे थे वो तो रिजेक्टेड है। नहीं नहीं, नो 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 नो,
Order for delivery of purchase.
कोई बात नहीं, हर चीज रिवर्स हो सकती है। नहीं देखिए, आई टेल यू वन थिंग, आई एम वेरी वेरी सीरियस अबाउट द डिलिजेंस ऑफ द काउंसिल। बहुत ज्यादा इंटेलिजेंस की जरूरत नहीं होती, लेकिन डिलिजेंस इज इम्पोर्टेंट। चलिए,
Item 2, second appeal 97 of 2022.
नो,
Writ of delivery of possession has been issued. The learned executive court has
इतना दिन से क्या कर रहे थे?
date रख दिया 6 तारीख को
कोई बात नहीं, हाँ
for
बताइए।
report.
But इसमें notice दिया था, there is an IA for substitution. They have informed under order 2210A, and then we have filed an IA 10084. 5th of August 2025, order number 38 number.
Respondent number 2 has appeared by her. Sir,
Two has
this
appeared.
report is valid upon respondent number 1 and 3A to 3A. Sir, this is valid.
Yes, but we have just checked the office note also, because it was sent to police.
Respondent notice was issued upon the proposed legal years and successor of respondent number 1,
And 3D.
3D.
Yes.
तो क्या हुआ इसमें?
बट इसमें 3D का जो है ये रिपोर्ट है कि 3D के का आधार कार्ड लेकर के उसको फाइल कर दिए हैं।
Just a moment. Respondent number 1,
हाँ,
notice served through WhatsApp.
व्हाट्सएप वो बोले रिपोर्ट जो है कि उसका एड्रेस पे नहीं मिले तो उनका व्हाट्सएप नंबर को लेकर के व्हाट्सएप पे नोटिस भेज दिए पुलिस का रिपोर्ट। ऑल्दो रिस्पॉन्ड नंबर
Respondent number 1 कहीं WhatsApp notice हमने नहीं received।
हाँ वही नोटिस तो
और उसके बाद और इसके
3A 3D का जो बच्चा लोग है,
एक चीज और है,
हाँ।
नेम ऑफ रेस्पोंडेंट नंबर 1 as mentioned in memo of appeal is Puliki Devi.
हाँ,
However, in para 4 of the IA, the same has been mentioned as थोड़ा spelling error. Pulaki Devi. इसको आप थोड़ा सा मैच कर लीजिए.
बट एनीवे रिस्पॉन्ड नंबर 1 जो फुलाकी है उनका डेथ हो गया, उनके बच्चे जो है पंचम उनको नोटिस दिया.
हाँ.
तो
ठीक. लिखिए. ऐसे नंबर 97 of 2002. Let Fred's notice be issued upon the legal heirs and successors of upon the proposed legal heirs and successors of respondent number 1. The notice served through WhatsApp is not acceptable. ये पुलिस स्टेशन वाले लोग इतना शॉर्ट में ये सब काम क्यों करते हैं भाई? हाँ?
पता नहीं आधार कार्ड भी लेके उस पर साइन करा के उनको विटनेस से भी साइन कराना चाहिए, लेकिन ये पुलिस के सामने भी
उनका सर्विस रिपोर्ट आया है.
हाँ हाँ रिपोर्ट है. सर्विस रिपोर्ट मतलब एक खाली फॉरवर्डिंग लेटर बना के देती है.
Let fresh notice be issued upon the legal heirs and successors of respondent number 1 in IA number.
IA number 10084
In IA number 10084
84 of 25.
of 2025 through the concerned police station. The notice has to be personally served in presence of witnesses, and copy of Aadhaar of the person to whom the notice is being served, self-attested copy, is also required to be taken while serving the notice. Notice served through WhatsApp is not accepted as valid service in the eyes of the law.
In addition to this, Lordship will also permit me कि हम उसको registered post से speed post से हो गया कि उसे भी भेज दे. In addition to this.
In addition to this, then let the notice be also issued to the proposed legal heirs and successors of respondent number 1 through speed post. The requisites for both the processes be filed before this court
That was
within a
Friday.
period of 2 weeks.
हाँ.
Within a period of 2 weeks from today, office to track speed post delivery. Post this case on. छुट्टी के बाद चला गया. अब
छुट्टी के
आप
बाद.
इस वक्त में क्या है हम नहीं जानते.
Sir,
छुट्टी के बाद
हाँ.
you test your destiny.
But can I request one more thing? But if there is a soft copy अगर है तो हम लोग को मिल
वो
जाएगा.
आपको ऐसे ही मिल जाता है. अगर है तो मिल जाएगा, नहीं है तो नहीं मिलेगा, क्योंकि ये पुराने रिकॉर्ड्स का बहुत चित्रा हो गया. पोस्ट 15 अक्टूबर.
इसका चाहिए
कुछ कर दे.
एनसीआर का नहीं.
NCR
आप रेस्पोंडेंट की तरफ से हैं, किसकी तरफ से?
दिस वन है नंबर
काउंसिल पर रेस्पोंडेंट प्लीज प्रेजेंट. हाँ देखते हैं 15 अक्टूबर.
50 तो.
Item 3, second to 55 of 2003.
Please, Your Lordship. Well, there was a direction for serving the notice upon respondent number 1 and respondent number 5. However, the office report says that the notice has not been received by 1, 6 and 5, 1 as yet.
In addition, I am appearing on behalf of respondent by the legal counsel.
Legal heirs of respondent number 1.
Yes.
Your file पकड़ा था.
Yes.
Notice has been served to the respondent number 3 as per report. The name of respondent number 2 deleted by the order of the submitted. LCR has been returned back, isn't it?
Yes, ma'am.
This matter has been remanded from Supreme Court.
This part is-
There is one matter which has been remanded from Supreme Court. There are so many pending IAs.
Minutes. Some have been disposed by your lordship on the last date minutes. There was an IA 5046 with respect to the modification that has been allowed by your lordship. And there was case 5045 in connection with IA number 8417. That was for substitution of respondent number 1 and 5.
इतने सारे आगे अलाउ हो गए हैं तो फिर ये यहाँ पर 25(8) which has been allowed.
Minutes 5046.
That respond number 4 has not died.
Yes.
तो ये यहाँ पर इसमें क्यों दिखा रहे हैं? आईए पेंडिंग कौन कौन से आईए पेंडिंग है? समीर जी आप बताइए. There are so
IE
many
pending.
IAs.
सारे open.
सारे पेंडिंग है आप बोलते हैं अलाउ हो गए.
Minutes 5046 has been allowed by last dated only. Minutes
कहाँ है ऑर्डर दिखाइए.
4th August.
ये तो अलाउड है 5046. ये क्यों यहाँ पेंडिंग है? और 5045
Minutes 5045 is in connection with the substitution of respondent number 1 and 5 minutes. The lordship was directed to serve notice minutes. It has been served and respondent number 1 is appearing. However, the office note says minutes that respondent number 51 has the notices has not been received on 5-1 as yet.
You see, the first is in compliance of order dated 4/8 notice has been issued to respond number 1 and 5.
Yes, ma'am.
The proposed legal years 1 to 4 and 5(1). Right? Legal years of respond number 1 as 1 to 1/4 have appeared by filing वकालतनामा. As per office note, the legal years of respondent number 1 within bracket Roman 1 and 1 within bracket Roman 6 have appeared by filing वकालतनामा. 5(1) का क्या है? Service report.
Minutes, the respondents indicate that they are filing the wakalatnama for all the respondent number 1.
5(1) की बात कर रहे हैं.
5-1.
हाँ.
Minus 5-1. 5-1 has not been served yet as per the record.
समीर जी, ये किसने बनाया? ये respond number 1 and 1/6 का तो लिखा है. ये सर्विस रिपोर्ट रिसीव्ड है, इसका क्या मतलब है? सर्व्ड है, अनसर्व्ड है, क्या बताएंगे? 5(1) का सर्विस हुआ? कौन है ये लोग जो ऑफिस नोट बनाते हैं? एकदम अनट्रेन्ड लोग हैं भाई, इन लोगों से नहीं हो सकता है. Who are these people who are making this office note? 5(1) का सर्विस रिपोर्ट क्या है? आप बताइए.
Minutes, I could only verify the records. I do not have the information.
No, it must be there in the records only. You tell me.
Minutes, the record says that it has not been served yet.
which letter, which document says?
Well, it's the office note dated.
What is the name of respondent number 1?
5-1.
5-1?
Minus.
Delete Kumar Singh. Substitute.
Delete
Propose
Kumar
substituted here.
उस जमीन से हमको कोई मतलब नहीं है. It has been served. It has been served. वो बोलता है उस जमीन से हमको कोई मतलब नहीं. That is
That
his
means
own.
he is
That
not-
is it has been served.
Yes, sir.
Notice upon respondent number 5 within bracket 1 has also been served. ये कौन सा आईए है?
This.
आईए number 5045.
Minus.
Counsel for the appellant has submitted that petition seeking substitution be allowed as paid for in IE number 5045 of 2024. Considering the aforesaid submissions, आपको कोई objection है?
Delay here. So much delay, but he has not filed the
They are not appearing and you are representing whom?
respondent number 1 legal here.
आपको counter file करना है?
Last by time.
हाँ?
So just appear हुए. I want to tell.
Counsel for the respondent number 1 within bracket 1 and 1 to 1 within bracket C, 1 within bracket 6. Praise for and is allowed time till Friday to file a response to IE number 5045 of 2024. Pose this case on Monday.
So at least 2 weeks may be granted. All the
आपको वकालतनामा दिया तो आप जवाब नहीं पूछे उससे?
फाइल भी तो करना.
नहीं, फाइल करना तो क्या?
और एक चीज हम आपको ध्यान में लाना
आपको
चाहिए.
जो वकालतनामा लाके दिया,
ठीक है.
आईए का कॉपी लाके दिया होगा, तो आप उससे पूछे नहीं? You allowed it to go.
एक चीज हम पॉइंट आउट करना चाहते हैं कि जो ये केस जो 2003 का है, आज 2025 है, only on the part of the alleges of the appellant. This case was dismissed for default for two times.
उस समय जब रेस्टोर हुआ था,
उस समय भी हम अपोज किए थे, फिर भी रेस्टोर हो गया, ठीक है. लेकिन मेरा कहने का मतलब है कि ये जो इतना डिले हुआ है, this is not on me. Laches on the part of the appellant. But your lordship has not given my time for the counter affidavit, only 3 days or 4 days. This is injustice on the part of the respondent
कितना
number
साल
1.
आपको टाइम चाहिए? How many years do you need to respond?
Only
दो
2
चार-
weeks.
Hmm?
Only 2 weeks.
When did you
क्या
come
कि
to
बाहर
know?
में है, उन लोगों को बुलाना.
Date of death कब है? Date of death बताइए.
Minus.
And did you inform the court that they have expired? Did you take any steps to inform the court that these people have expired? Respondent, I am asking
No,
you.
yes, no.
No steps were taken from your end. When did he die? आप बताइए, आपको डेट ऑफ डेथ भी नहीं पता?
8/11/2018.
8/11/2018.
Respondent number 1.
Respondent number.
क्या मैटर है? What is the matter?
Respondent number 1 died on 5/7/2020.
2000?
As per my recollection. Respondent number 1 died on 5/7/2020 minutes, and respondent number 5 died on 23/5/2005. Once Kanti Devi. 5/7/2020. Well, let's may kindly have IE number 5.
Appellant has died on 18.
लास्ट टाइम आपका रेस्टोर कब हुआ था?
Well, it's my application was restored on Well, it was restored in the year 2024.
At the time of restoration, the substituted years were there.
No.
No, my lords.
It was restored without notice.
Yes, sir.
आप लोग नोटिस के लिए भी नहीं बोलते restoration.
Well, there was IA was there
आइए for what?
for substitution.
In the restoration application.
No.
Well, may I verify my CFA?
Restoration अगर without notice हो गया है, तो restoration is also again with respect to a dead person. उस restoration का क्या sanctity? बताइए. बहुत खुश होते हैं restore करा के पहला दिन. ये हो गया restore. It's an achievement. Civil litigation ऐसे नहीं चलता है. इनको 2 weeks टाइम दे दीजिए. ये मेरे लाइफ टाइम में डिसाइड नहीं हो पाएगा, हम समझ नहीं. अब बताइए कब रखें, कौन सा साल? Which year do you want this litigation to be taken?
It's any day after 2 weeks.
After 2 years?
2 weeks.
I thought 2 years. ये नहीं होगा ना, नहीं होगा. बहुत कॉम्प्लिकेशन है.
My lords.
बहुत कॉम्प्लिकेशन है. आप रेस्टोरेशन कराएं विदाउट सब्स्टिट्यूशन.
Yes.
और आपने चैलेंज किया
हमको
सर.
पता ही नहीं था.
आप
अब तो हम जान रहे हैं कि डेथ माने सब्स्टिट्यूशन.
आपने तो चैलेंज ही नहीं किया रेस्टोरेशन. बिकॉज एक बार तो रेस्टोर हो गया है ना.
2 बार
रिकॉल नहीं होगा. तो आपको चैलेंज करना पड़ेगा, अदरवाइज तो रेस्टोर हो गया सो हो गया.
कंकरेंट फाइंडिंग में मेरे पेपर में मेरिट में भी होते हैं.
लग तो नहीं रहा है कि आप तैयार हो पाएंगे, जितना आपको टाइम चाहिए.
नहीं, असल में तो बाहर रहते हैं और अपडेट कराना पड़ता है बुला के, इसलिए हमको
वकालतनामा बुला के नहीं लेना पड़ता है क्या? वकालतनामा लेते समय कोई इंफॉर्मेशन नहीं रहता है. पता नहीं कहाँ से वकालतनामा मिलता है. पोस्ट ऑन 30th October. 30 October.
Item 4, second bill 336 of 2004, along with item 5.
Your Lordship, in second appeal 108/2005, 3 IAs are pending, Your Lordship.
What?
एक आई Your Lordship सब्स्टिट्यूशन के लिए है, उन्होंने वेट हो गया था Your Lordship, क्योंकि लॉकडाउन के टाइम उनकी डेथ हुई थी Your Lordship.
Who has expired?
In other case also Your Lordship, एक IA is giving me one IA in second appeal 336/2004, in which it has been prayed that appellant name of the respondent must 28.
आप एक अपील उठाइए.
जी Your Lordship.
Your essay number 108 of 2005. What is the pending item?
Your Lordship, 3 IAs are pending. One IA is for abatement. One IA is has
Who has expired and when?
Kareem Mia, appellant number 12, was expired on 31/8/2020, Your Lordship, and he has been abated, Your Lordship. So Your Lordship, for setting aside, it has been prayed that abatement will be set aside, because at that time there was complete lockdown in the country, and
Yes, written. Any objection to substitution? Appellant number 12 has expired. Do you have any objection? Do you have any objection, respondent?
जी जी
Do you have any objection to substitution?
जी
बताइए क्या objection है? Have you filed any counter affidavit to this?
Your Lordship, I think he's not responding, he's just appearing, taking time on behalf of the respondent.
Who is appearing for respondent? Who are you?
लखन चंद्र राय सर ये बगल कोर्ट में आया है वही इनको भेजे थे कि आइए पिटीशन देने के लिए
आइए petition?
मीटिंग
Your Lordship, हमको एक आइए पिटीशन दिए है, लॉर्डशिप ये 336 का आइए पिटीशन दिए है।
कितना डेटोरिएट कर गया अपना हाईकोर्ट, हमको समझ में नहीं आया।
Your Lordship, हम इसी में
आप लोग को खुद ही नहीं पता है क्या एक्सचेंज कर रहे हैं आपस में?
नहीं, ये लॉर्डशिप हम एक्सचेंज नहीं कर रही है, हम तो एक आइए दे रहे हैं तब से लखन चंद्र राय।
This IA has already order has been passed in this IA.
Which IA? IA number?
336 with regard to deleting the name of 28A that has been deleted. 28A name has
इसमें दूसरे केस में कोई पेंडिंग आई नहीं है ना?
नहीं उसमें
336 में नहीं, 108 में आई है।
हाँ 336 में कोई पेंडिंग आई नहीं।
हाँ पेंडिंग नहीं है उसमें।
खत्म?
हाँ इनके में है।
इसमें बताइए पेंडिंग है। इसमें क्या सब्स्टिट्यूशन में आपको क्या परेशानी है सब्स्टिट्यूशन?
हमको कोई परेशानी।
ये 2022 से ये आइए चल रहा है, कोई काउंटर नहीं ना फाइल किए लोग आइए का?
हमको कोई परेशानी नहीं है। सब्स्टिट्यूट हम सब्स्टिट्यूट ऑलरेडी हो चुके हैं मेरे अपील।
इसका आइए का कॉपी का
7640
ये तीनों आइए इस रिकॉर्ड में नहीं 108 आइए लगा हुआ है, आइए रिकॉर्ड में है भी कि नहीं है, ये कौन और कब चेक किया?
ये पेंडिंग है बट इसमें नहीं लगा।
क्यों नहीं लगा हुआ है और आप लोग क्यों नहीं चेक किए ये सब चीज? ये किसका काम है चेक करना बताइए? 3 लोग यहाँ पर हैं, क्या करते हैं आप? रिकॉर्ड में आइए नहीं है, आइए का नोट बना हुआ है। जब तक काम नहीं खत्म हो ना घर मत जाया करें। हम भी जाते हैं 7:30 बजे, आप लोग भी किसी को जरूरत नहीं घर जाने का जब तक हम यहाँ से ना चले जाएं। आइए मंगाइए इसका, यू जस्ट वेट फॉर सम टाइम।
Item 6, second appeal 14 of 1995.
There is substitution petition, my lord. Right, IA number 10834 of 2025.
Substitution of
Narendra Bhagat. He is the respondent of 1C. He died on 25th of March 2025. It has been, the substitution petition has been filed after 49 days delay on 12th of August 2025. I bring up that the delay may be condoned here.
who is for the respondent? Who is for the respondent?
There was only one respondent, my lord. He died, and then after these 5 sons have been substituted, one of the substituted son, Narendra Bhagat, is dead. And Mr. Yogesh Modi had appeared on behalf of one of the
IE number 10834 of 2025 in second appeal number 14 of 1995. Learned counsel for the appellant has submitted that respond number 1C has expired on
25/3/2025.
25/3/2025. The name of legal heirs and successors have been mentioned in paragraph 4 of the interrogatory application seeking substitution. Let notice be issued to the legal heirs and successors of respond number 1C. In ID number 10834 of 2025. Under speed post as well as under ordinary process. Only speed post and under speed post for which requisites be filed by Thursday.
Alright.
Post this case on 22nd September. आपको अगर रिकॉर्ड नहीं है तो आप अपना रिकॉर्ड सब लेकर तैयार रखेंगे क्योंकि तब तक तो सर्विस रिपोर्ट आ ही जाएगा. ऑफिस इज डायरेक्टेड ट्रैक स्पीड पोस्टिंग.
If soft copy is available, then
We do not know. You have to line up with the court master.
okay.
Item 7, second case 132 of 1998.
Yes.
One case has been fixed on Thursday. The first case. That day I will not be available in Ranchi Milan, so I have a personal one outside.
We have already fixed the case with the consent of the parties. और आप उस समय यही आप बताइए क्या बनता है?
I filed the IE petition for substitution of
Substitution of
respondent number 1 में उनका डेथ हो गया था. Thereafter
नोटिस किया है.
नहीं.
दो आईए क्यों फाइल हुआ? दो का सेम नंबर है. दो आईए क्यों दिखता है? जो बाद में फाइल. आईए नंबर 11057 of 2025 in essay number 132 of 1998 written bracket P. This petition has been filed for substitution of respondent number 1, namely Bhagwan Das Rajdev,
Yes.
who is said to have expired on 4/5/2011. The names of legal heirs and successors has been mentioned in paragraph 2 of the interrogatory application. Let notice be issued to the proposed legal heirs and successors of respondent number 1. For which requisites under speed post be filed by Thursday. Post this case on 22nd September. Office to tax speed post delivery.
10 days time.
IN
IE में कितना दिन का और
3
नोटिस
दिन का टाइम दिए. थर्सडे तक फाइल कर दीजिए. थर्सडे तक फाइल कर दीजिए. IN नोटिस स्पीड पोस्ट
केवल इसके
केवल स्पीड पोस्ट.
Item 8, second appeal 170 of 2002.
Who is for the appellant? टाइम नहीं
वो
मिलेगा.
वाला हो गया. Substitution petition.
क्या चीज?
Substitution petition वाला तो करने होते.
कौन सा वाला?
ये ऐसे 132 हो गया. और ये
Essay 170 of
Yes,
2002.
yes.
You are for the respondent?
I am for the respondent.
Where is the appellant? You are the landlord or the tenant?
I am the landlord, Your Worship. In this case, although Your Worship, last statement, what happened? This respondent, he has also died. 3 legal heirs there, but all 3 died outside India, Your Worship. So that ought to be.
So everybody has
And
died.
that appeal before the Deputy Commissioner was because the substance of question which has been framed, Your Worship.
What happened before
That has already been dismissed long back. Whether in view of the fact that the appeal filed with the appellant against the appeal passed by the House in fixing the failure to finding for the appellant to complain.
As such, no substitution of decree holder has been made till date.
Yes, Your Worship.
तो क्या करें, इसको डिसमिस कर देते हैं, क्या करें? यहाँ पे आपको भी कोई इंस्ट्रक्शन नहीं है?
नहीं, मेरे पास तीनों बाहर ही रहते हैं, they stay outside India, but they are मतलब now whatever be on their it will be decided.
When did they expire?
They expired, Your Worship. I think 2019, Your Worship. Because as per the instruction, we have made this, we have filed, we have drafted the substitution petition in the year 2019. But since nobody has come to swear an affidavit, because one of them has to come and swear.
Sole
He
appellant
died,
has been
yes.
substituted.
Yes, sole appellant has been substituted. He died long, just some days.
Sole respondent has
Sole
been
responding, Your Worship, 23rd October 2018.
23
10 2018.
10 2018. Sole respondent died.
Yes.
Okay. Now no substitution has been filed. It rests with the sole respondent.
This is the death certificate also. Your Worship.
Okay. And this deputy commissioner has dismissed the appeal long back.
Yes.
We have got that report.
Yes. Even their incident happened.
Deputy commissioner का report नहीं आया. You have a copy of the dismissal order?
The lawyer who was conducting in the court bureau, he has informed, we have taken instruction from him. So the brief was given by through him.
Execution में भी नहीं हुआ है substitution. इसलिए कुछ हो नहीं रहा.
बिग बॉस करना था हमारी execution के substitution.
आपको क्या बोलना है? इसमें sole respondent has died in 2018.
There was a direction of this.
Then your appeal has abated?
I will file the substitution petition. You have to make the last order passed with this honorable court. There is a direction to provide the names of legal heirs of the sole respondents. Matter did not supply.
I have the names here, but the thing is, I have the names, I have the Bakalatama, but somebody has to come and swear an affidavit. So this petition is ready, but nobody.
नाम दे date of death or
Counsel for the respondent has submitted that sole respondent has expired on 23/10/2018 and
24/10.
24/10/2018.
No, sorry. Date of death is 23/10, registration is
23/10/2018. and she has got a copy of the death certificate,
Yes.
which is being handed over to the council for the appellant. She has also provided the names of legal heirs and successors of the sole respondent.
One wife, one baby and one. She, there's one his wife, son and daughter. There are three babies.
Who are three number, wife, son and daughter. She submits that the same is not being filed through affidavit as nobody has come to swear affidavit.
It is this tree also.
We don't bother whatever be the reason. The report from the net court receives reveals that the decree holder, namely Supriya Majumdar, has not been substituted in the execution proceedings. So far as the report from Deputy Commissioner Dhanbad is concerned, the same has not yet been received in terms of order dated 5/8/2025. Office is directed to issue a reminder to the Deputy Commissioner. कहाँ का Deputy Commissioner है? Dhanbad. To ensure compliance of the order of this court. At the request of the counsel for the appellant, holds this case on 22nd. उस दिन अबेट कर देंगे.
इसलिए हम तो फाइल कर देंगे.
देखिए क्या करेंगे. ये ऑर्डर को ना आज साइन करा.
From daily list of panelists was item change, second quit 425 of 2018.
This case execution is completed.
essay number 425 of 2018. It is landlord tenant?
No. It's a family settlement.
Sorry?
There was a partition suit that was filed by them. Subsequently, I have purchased from the rightful owner that part which is in this before auction. And there was a reversal from the appellate court, the findings of the appellate court, my lord. Point number 3 at internal page 11.
Where is the substantial question of law involved in this case?
The substantial question of law has been framed, my lord, by order dated 20/12/2023, order number 9.
When was the execution completed?
Well, last year, sir.
It has been restored twice.
Yes, of course. There was a dispute between two brothers over one staircase. That one was allotted to one Mullah Yadav by virtue of family settlement.
Learned counsel for the nobody appears on behalf of the appellant. The counsel for the respond number.
So respond.
Counsel for the sole respondent is present. He has submitted that the decree has already been executed. Correct?
Yes.
He has also submitted that this case was earlier dismissed for default twice.
10 minutes.
क्या कर रहे हैं? पास ओवर नहीं करेंगे, अभी डिस्मिस फॉर डिफॉल्ट करने वाले हैं, कुछ नहीं करेंगे, आप बहस करिए या फिर बस क्या चलेगा फिर?
16
आपको बहस करना है तो फिर हम तो डिस्मिस फॉर डिफॉल्ट कर ही रहे थे, अभी बीच में कहाँ से घुस गए? आप फाइल खोलिए, बहस करिए। 2 बार आपका डीएफडी हो चुका है, राइट? फाइल भी सीनियर लेके चले गए क्या घर? आप हैं इसमें? एग्जीक्यूट भी हो गया है आपका तो डिग्री, अब क्या है, किस लिए लड़ रहे हैं 2 भाई मिलकर?
Section 144 is still exists also. If the appellant succeeds also, there is provision.
That's right. 2 भाई मिलकर किस लिए लड़ रहे हैं?
थोड़ा सा जमीन
के लिए जान दिए हुए हैं। क्या है
The
बताइए?
trial court also dismissed the suit and order and adverse influence has been drawn against the plaintiff that the procedure was not imposed lordship, and that judgment was reversed by the lower appellate court.
तो क्या हो गया उससे?
I am the defendant. He is the plaintiff. I title suit for declaration right title interest.
Declaration of right title interest या partition suit?
नहीं, declaration of right title suit.
चलिए आपका सब्सटेंटिव क्वेश्चन ऑफ लॉ है, बहस करिए।
जी।
Appeal was allowed.
Appeal was.
The suit was decreed.
Suit was dismissed.
Suit was dismissed.
The Lenatile court held that the person who purchased the land lordship
एक सेकंड
did not
आराम
depose.
से hold on. Suit was dismissed. Plaintiff filed the appeal was allowed.
Appeal was judgment of reverse.
Judgment of reverse. Defendant is the appellant now.
Yes.
Now let us see the
Substantial question.
substantial.
Order dated 2012-2023. Whether the findings of the learned court of appeal view are recited due to not drawing the adverse influence on account of non-examination of the plaintiff. Whether the findings of the learned court of appeal view are recited due to not meeting the reasoning of the trial court while reversing the judgment on extraneous consideration.
Let us see what was the suit for.
The plaintiff filed suit for declaration that plaintiff is the owner of the suit property and defendant has no right over the same, and prayer has been made for grant of permanent injunction restraining the defendant from interfering with the peaceful possession of the plaintiff over the suit property. Lordship, may I see issue framed by the trial court?
केस ऑफ द प्लेंटिफ दोनों का केस पढ़िए, उसके बाद इशू पढ़िए.
The case of Para 2 laws. The case of the plaintiff is that the husband of plaintiff and defendant are the full brothers, father-in-law of the plaintiff, and defendant own and possess a piece of land with built a house, Jalasar Road, Devghar. Let Manulal Yadav felt difficulty in joint enjoyment of the property, and there was an amicable family settlement between Manulal Yadav and his two sons. The family settlement was done through the registered deed of settlement number so dated 5/3/1987. In that family settlement, late Manulal Yadav was allotted 142 square feet of the land fully described in Schedule A of the land. Subsequent to the aforesaid settlement, the parties came in possession of their respective share along with Schedule A property belongs to Manulal Yadav. In northern side of the Schedule A property, there is a share of defendant that is 90.27 square feet of the land in the house just north of property of the defendant share allotted to husband of the plaintiff as 1925 square feet of land house. The further case of the plaintiff is that in the year 1981, late Manulal Yadav had need of some money of his personal use. Then he decided to sell the scheduled property and expressed his willingness to his both sons. The matter was conveyed by the Manulal Yadav by registered notice, but sons paid no yield. The plaintiff agreed to purchase the aforesaid land belonging to Manulal Yadav on consideration amount of 5,000. The plaintiff purchased the scheduled property from the late Manulal Yadav, a registered sale deed dated 18/6/1991 and same came into actual physical possession over the same. After purchase, he prepared a complete plan sanctioned by Devghar municipality and constructed the house. Northern part of the land constructed a staircase. Defendant also constructed the part, but no way to go his upper floor of the building. Then plaintiff gave temporary permission to the defendant to use her staircase for 1 year, and defendant assured her that in the meantime he would make alternative arrangement. Further, the case of the plaintiff, the defendant started using the stair. Case of the plaintiff with her permission, but since 1999 his dishonest intention grown up with intent to grab the property and started obstruction to the plaintiff from using the same. The plaintiff asserted that the staircase is only way to go the first and second floor of the building. On 12/10/2000, the defendant started some construction work in the staircase of the plaintiff, an act of the defendant in adverse to the right and title of the plaintiff, and defendant intervened the physical position of the plaintiff of the suit. The defendant appeared and filed WS-121 and denied the abatement of the plaintiff. The defendant asserted admitted that the registered family partition were according to defendant. The parties of the case were enjoying the property separately in all terms as of the convenience since before the family arrangement. According to defendant, first dispute was raised for the property of the mother-in-law of the defendant, and next dispute raised for cooperative law. The amount of loan was enjoyed by the plaintiff husband also. The case of the defendant is that late Manulal Yadav, the father of the defendant, had been living with the defendant till his death, and Shraddh Karma and other rituals were done by the defendant alone. According to defendant, Babulal Yadav constructed his house and hotel known as the Hotel Mayur, and defendant as well as made his residence in the hotel known as the Hotel Descenter. The factual position of the land is admitted by the defendant. Also, defendant admitted the position of the property as per the family arrangement. Further, the defendant asserted that both the son of Manulal Yadav orally agreed to maintain their father, but Babulal Yadav, husband of the plaintiff, did not maintain his father. According to defendant, Manulal Yadav had no need of money.
So there are two registered sale deeds.
No.
One is claimed by the plaintiff, other is claimed by the defendant with respect to the same suit property.
Same suit property.
The plaintiff's deed is of the year 1991.
Yes.
The defendant's deed is of the year 1994.
19.
किसका deed prevail करे?
According to law, the first salaried will be according to section 48 of the transfer of property.
तो फिर यही होल्ड किया और क्या होल्ड किया?
नहीं नंदे ट्रायल को होल्ड की नहीं कि the person who purchased the land did not dispose before that, therefore it
How
was
does that make a difference?
lordship
रजिस्टर्ड डीड है ना,
registered deed.
तो फिर अगर नहीं डिपोज करेगा तो क्या हो जाएगा?
But according to section 114 of the lordship, there is a decision of the Honorable Supreme Court.
नहीं, डिसीजन
Para 50 minutes. So, para 50 minutes. Where a party to the suit does not appear in the witness book, state his own case to note and does not offer himself to be cross-examined by other side, a presumption would arise that the case set up by him is not correct as has been held in the series of the decision passed by the previous High Court and beginning from the decision in Sardar so and so and so and so. This was followed by the Lahore High Court in so and so and so Bombay High Court. The procedure was not deposed before the London trial.
Purchaser means the plaintiff.
Wife of the plaintiff. Wife of the plaintiff is the purchaser of the land.
That's right.
She is deposed to power.
So far the contention is that the power of attorney,
अभी आपसे पूछूंगा।
the power of attorney cannot depose lordship.
एक सेकंड, ये जरा इश्यूज पढ़िए
जी।
और कौन सा इशू रेलेवेंट है
जी।
फॉर द पर्पस ऑफ दिस केस।
Para 4 lordship issues preempted under trial court lordship. The issue number 8 and 9 is relevant lordship.
8 and 9 to 7 and 6 and 7.
6. Whether the Nirmala Yadav is the owner of the suit property and has sold the property to Meena Devi, wife of Babu Lal Yadav on the
है ना? This and 7.
7 is the whether the sale deed number shows 1920 or sale deed number
Valid and genuine.
valid and genuine.
ठीक है। Whether the disputed staircase has been
Para
constructed
6
by
lordship, the findings also. Para 6.
कौन-कौन इसमें एविडेंस में आए हैं? On behalf of the plaintiff, five witnesses have been examined.
But the purchaser was not deposed lordship.
That's right. On behalf of the plaintiff, sale deed, etc. There is a finding with regard to 5 and 6. 1, 2, 4, 5 and 7.
Lordship, para 6 lordship.
Para 6.
Para 6.
इसमें 5 के साथ 7, 5 के साथ 6 नहीं.
6 नहीं, 7.
Where is issue number 6?
Issue number 6. According to us, there is no finding, so I will issue number 6.
Right of preemption suit पे तो नहीं decide होता ना? Cannot do ना? चलिए। आप पढ़िए क्या पढ़ना चाहते हैं?
Issue number 6 lordship. findings issue number 6, Lords. The aforementioned issues are decided jointly for proper education from the family partition settlement dated 5/3/1986 admitted that by both the parties. Plaintiff asserted that she is the owner of the suit land where the STR case is in existence constructed by her through sale deed number so executed by the father-in-law. Further, plaintiff
The buyer is the plaintiff. The buyer of the property is the plaintiff. The
Plaintiff.
daughter-in-law is the plaintiff.
no, wife of the plaintiff is the purchaser.
No.
Meena Devi.
Daughter-in-law.
Daughter-in-law is the plaintiff.
Sorry, daughter-in-law. Sorry.
Daughter-in-law is the
Meena
plaintiff
Devi.
also.
Meena
Devi. Yes, it is the plaintiff.
Yes, daughter-in-law who did not depose.
Maybe it did not depose, but she is the plaintiff.
Sick plaintiff.
आगे बताइए.
On the basis of the plaintiff has got very cause of action for the suit and suit is claimed as is not maintainable. Accordingly, issue number is decided in favor. Now the question of whether the suit barred by any civil law, whether there is a right of preemption in favor of both the parties before the alleged execution, both the same deed executed by the same person by no law in different date. In this regard, I have to scrutinize the evidence available in the judicial record. According to plaintiff, the plaintiff para 6 she asserted a notice was given to the both the.
No, just a moment. Is there any the right of preemption has been this issue number 4 is regarding right of preemption. Does the court has a jurisdiction to decide right of preemption?
Issue number 4. Yes, there is a 3 and 4 issues.
No, there is no, the court does not have the jurisdiction to decide right of preemption.
Absolutely right.
But still the court has framed this issue and decided the right of preemption and talked about the notices served. मतलब नहीं है. आगे पढ़िए.
Now the question. Now the court para civil law. Now the question whether the suit is barred by the civil law, whether there is a right of preemption in favor of both the parties who sued before the alleged execution of both the sale deed executed by the same person, but the minimal law marking different between these that has no scrutinized the evidence available in the judicial record. According to plaintiff of the plaintiff para 6, she accepted the notice was given to both the brother Babu Lal Yadav and Shankar Yadav by late Minu Lal Yadav, their father, but in WS in para 5 and page 5 of the WS defendant accepted no registered notice ever served and conveyed to the defendant regarding the transfer of the sale out sale of the late Minu Lal Yadav. This fact has been accepted by the plaintiff or denied by the defendant. Then plaintiff has to prove the fact. Owners have to prove the same in all the facts. What is the oral evidence in the point available in the judicial level? There are 5 witnesses have been examined on behalf of the plaintiff, but out of 5, 4 are formal who identify the registered deed and municipal building plan, which is they have started nothing with regard to the fact of the case. Only with the PW4 Babu Yadav, who is the husband of the plaintiff, with the material. Here it would be to mention here that Babu Yadav PW4 has come in the court in the post because the facts on the basis of the general power of attorney executed by his wife, the plaintiff. Here again, Orki to mention here the plaintiff accepted that the great Minu Yadav who are in need of money. Minu Yadav sent a notice to his both sons. Lastly, executed the sale deed in favor of. She paid the consideration amount of 5,000 to the Minu Yadav. These all the facts are meeting the personal knowledge of the plaintiff as to when the notice was sent by the Minu Yadav, why he had need of money, out of which account of from which the sources of 5,000 are paid to the late Minu Yadav by the plaintiff. As the plaintiff is not working lady, rather she is a housewife. There is no case of the plaintiff the amount was paid out of the estate. So in my view, she is the best person witness to because he clarify the subject matter before the court. PW court Babu Lal Yadav has come before the court on the basis of general power of attorney, which is not registered. What is the legal value of the statement given by PW for Babu Lal Yadav before the court on the basis of general power, especially when he had no personal knowledge about the same as discussed above. In this regard, the provision contained order 3 rule 1 2 are very important, which read as follows: the appearance may be in the person by recognized agent or by pleader. Any appearance application for act to any court required or authorized by the law to be made or done by party in such court may accept where the otherwise expressly provided by any law for time being made or done by the party in person. or why he is recognized agent, or why the pleader appearing, applying or acting as the case may be on his behalf, provided that any appearance in the court so direct be made by party in the person. Recognized agent means the recognized agent of the party by whom the such appearance application and act may be made to them. The person holding the power of attorney authorizing them to make and do such appearance application and act on behalf of the party. The person carrying on trade or business for any the name of the party not residing within the local limits of the jurisdiction of the court, within which the limit the appearance application or act is made or done in the matter connected with such trade or business only. There is no other agent expressly authorized to make and do such appearance application in the aforesaid text. The person does some important judgment in the unescaping laws, para 9 laws. That in regard to the
The
provision,
sale deed was also not challenged.
sale deed was not challenged.
Not challenged. 91 sale deed was not challenged for any reason.
91 sale deed was not challenged by the plaintiff.
Yes.
I am the defendant.
You are the defendant.
Defendant.
You also did not challenge the 91 sale
Yes, the defendant was also not challenged.
deed. You have not challenged. So, how does that make a difference? सेल डीड है, पैसा दिए हैं, ट्रांसफर हुआ है. There is a presumption in connection with issuance of सेल डीड. तो पार्टीशन में ऐसा कंडीशन होता है?
नहीं, पार्टीशन नहीं, डिक्लेरेशन ऑफ राइट टाइटल इंटरेस्ट.
पार्टीशन में ऐसा कंडीशन होता है क्या? ये सुनेंगे, ये देखेंगे, ये बताएंगे.
पार्टीशन में सुनेंगे.
क्या है आपके केस में? Merely because power of attorney, who is also the husband, कोई ऐसा कोई.
But he cannot depose also. Power of which is
He
not
did not. Just a moment. The court has held that there were certain reasons which were like Nunu Lal Yadav was in need of money. Irrespective of the fact whether a person is in need of money or not, he can always sell his property. Where is the legal part?
But the person
Where
is
was
person to say that what is the
Need not. Once a person has executed a sale deed, वो क्यों सेल डीड एग्जीक्यूट किया इसको प्रूव करने की क्या जरूरत? कंसिडरेशन वाज देयर, राइट?
yes, yes.
Right, he passed on. There was no need to require. There was no requirement to examine the power of attorney. It was specific performance of contract.
But the power of attorney law which is unregistered who depose before the law.
He has deposed. He has deposed. The court has
But
accepted
according
his
to our law,
deposition.
say,
That is not the substantial question of law.
Which is not, yes, which is
That
not
is
the
not the
substantial
substantial.
question of
So
law.
let's not go into that. What happened by the learned first appellate court?
First appellate court held that the person who purchased the land, he need not to depose the.
Yes,
depose.
need not be deposed. That's
This is the finding.
absolutely correct. We need not depose. What do you have to say?
Findings of the appellate court,
Where is it?
internal page 11. Before entering into the appreciation of the evidence and scrutiny of impugning judgment and degree of learned
First, you refer to the point for determination.
point for determination. The points are formulated for determination appeal.
Para 11.
Whether the appellant or plaintiff has got right title and interest over the suit described in Schedule B of the appellant on the basis of the sale deed allegedly executed by Nulal Prasad Yadav in favor of the appellant plaintiff in the year 1991. Whether non-examination of the plaintiff or appellant before the learned court recorded rendered the claim of the appellant or plaintiff unproved. Whether the terms and conditions of the alleged settlement deed were violated by the plaintiff in getting the share of Nulal Prasad Yadav in A19 by virtue of registered deed of sale. First to point number 3, the ratio has been. Point number 3.
Yes.
Before entering into the appreciation of the evidence and scrutiny of the impugning judgment and decree of the learned.
Point number 3 is not the substantial question of law.
Can you
Point number 2 is, my lord.
Point number 2. You come to point number 2.
Point number 2 is, my lord, internal page number 13, my lord, internal page 16. It has been contended on behalf of the respondent or defendant that appellant or plaintiff was not examined before the trial court to prove the and substance her case, and it was her husband who deposed on behalf of the plaintiff on the basis of power of attorney in his favor. It is further argued that power of attorney cannot depose in a suit before a court at the place of principal in regard with facts which are exclusively in the personal knowledge of the party. But husband of the appellant deposed before the court in regard with facts which could have only been in the exclusive knowledge of the appellant plaintiff, and as such the learned trial court did not rely on the statement of the husband plaintiff and rightfully dismissed the suit, holding the judgment appellant did not prove her case. The learned trial court has referred clause A of Rule 2 of Order 3 of CPC in para 7 of the judgment, which shows the person holding power of attorney authorizing them to make and do such applications and act on behalf of such party can be done by power of attorney holder. The trial court has referred to a judgment of the Honorable Patna High Court reporting such and such, in which their lordship held that the general power of attorney cannot depose for the principal in respect of the matter which only on the principal can have the personal knowledge and in respect of which the principal is entitled to be cross-examined. Relying on the aforesaid vertical argument, the learned trial court held in its judgment that the respondent defendant were
Second appeal number 425 of 2018. For the learned counsels appearing on behalf of the parties. This appeal has been filed. Against the judgment dated, क्या डेट है जजमेंट का? आपका पैराग्राफ भी सही से नहीं लिखा हुआ. Judgment dated 6/8/2018 passed by the court of learned Principal District Judge Devkar in civil appeal number 5 of 2017. Decree signed on 6th of August 2018. Whereby the judgment passed by the trial court has been set aside. Judgment in decree passed by the trial court has been set aside. So far as the judgment of trial court is concerned, the same has been passed in title suit number 132 of 2001, dated 24 January 2017. Decree signed on 24/1/2017, whereby the suit was dismissed on contest. The suit was dismissed, the appeal was allowed, and consequently the defendant is the appellant before this court. This appeal was admitted for final hearing by order dated 20/12/2023 on the following substantial question of law. The records of the case reveal that the suit was filed for a declaration that the plaintiff is the owner of the property described in Schedule B of the plaint, a prayer for permanent injunction restraining the defendant with the possession of the plaintiff over the Schedule B property was also prayed for. As per the case of the plaintiff, the husband of the plaintiff and defendant are full brothers. The father-in-law of the plaintiff and defendant owned and possessed the property described in Schedule A of the plaint. There was an amicable family settlement between two sons of Nunulal Yadav, which was done through a registered deed of settlement number 568 dated 5/3/1987. And subsequent to the settlement, the parties came in possession of their respective share. Along with Schedule A property, which belongs to Nunulal Yadav. In the northern side of Schedule A property, there is share of the defendant to the extent of 1927 square feet of land and house, and the share allocated to the plaintiff was 1925 square feet of land and house. It was a case of the plaintiff that in the year 1991, Nunulal Yadav was in need of some money, and he decided to sell the property and express this to both his sons. And it was conveyed to both the sons. And ultimately, it was plaintiff who agreed to purchase the property and the plaintiff purchased the Schedule A property from Nunulal Yadav by registered sale deed number 1598 dated 18/6/1991 and came in physical possession of the same. It was the further case that she got the plan sanctioned from Devgarh municipality and constructed the house with the northern part of the land and also constructed staircase. The defendant also constructed his part, but there was no staircase to go to his upper part of the building. And consequently, the plaintiff had given temporary permission to the defendant to use the staircase. But since 1999, the defendant intended to grab the property and started obstruction to the plaintiff from using the same. And ultimately the suit was filed. The defendant had filed a written statement and denied the abatements of the plaintiff. And asserted that and admitted that there was a registered family partition, but according to the defendant, the parties of the case were enjoying the property separately in all terms as per convenience since before the family arrangement. It was the further case of the defendant that both the sons orally agreed to maintain their father, Nunu Lal Yadav, but the husband of the plaintiff did not maintain Nunu Lal Yadav. It was the case of the defendant that Nunu Lal Yadav had no need of money, and therefore he never expressed his desire to sell the properties which fell in his share. The notice in that connection said to have been sent by Nunu Lal Yadav was not served upon this defendant. It was alleged that if there is any sale deed executed in favor of the plaintiff, the same is fake and fraud. The plaintiff did not have any earning, and it was also asserted that the property was sold to the defendant by its sale deed number 342/359 dated 26/1/1994, executed by Nunu Lal Yadav. And the staircase was constructed by him. Thus, both the parties were claiming the property by virtue of registered sale deed. The plaintiff was claiming it by way of registered sale deed number 1598 dated 18/6/1991, and the defendant was claiming it by virtue of registered sale deed number 342/359 dated 26/1/1994. On behalf of the plaintiffs, altogether 5 witnesses were examined and 10 witnesses were examined on behalf of the defendant. And documentary evidences were also exhibited. Admittedly, the plaintiff did not depose before the court in person, but she deposed through a power of attorney, who was none less than her husband. The following issues were framed by the learned trial court. The issue number 1, 2, 4, 5 and 7 were taken up together, and the suit was held to be maintainable. The learned trial court posed a question as to whether the suit was barred by any civil law and whether there is right of preemption in favor of both the parties of the suit before alleged execution of both the sale deeds executed by the same person, namely late Nunulal Yadav, in different dates. By considering the oral evidences, the learned trial court recorded that out of 5 witnesses, 4 were formal witnesses, and only PW4, Babulal Yadav, who is the husband of the plaintiff, was the material witness who had deposed before the court on the basis of general power of attorney. He had asserted that Nunulal Yadav was in need of money and he sent notice to both the sons, and lastly executed the sale deed in favor of the plaintiff. And the plaintiff had paid the consideration amount to late Nunulal Yadav. The court was of the view that all these facts were within the personal knowledge of the plaintiff. And therefore, and also observed that Babulal Yadav had come before the court on the basis of general power of attorney, which was not registered, and ultimately held that Babulal Yadav that PW4 Babulal Yadav, being the power of attorney holder, his evidence did not have any legal sanctity, and it could not be accepted to prove the case of the plaintiff. The learned trial court recorded that the parties have not followed the mandatory provision of right of preemption. The learned trial court ultimately held that there was no evidence at all on both the sides regarding compliance of right to preemption, and as such both the deeds, that is registered deed dated 18/6/1991 in favor of the plaintiff and the registered deed dated 26/1/1994 in favor of the defendant, cannot be said to be legal document. And was of the view that since the plaintiff had not come herself and proved her case, and PW4 was examining her husband being the power of attorney holder, technically there was no evidence on the part of the plaintiff, and decided issue number Roman 2 against the plaintiff, and held that as there is right of preemption in favor of both the parties, issue number 5 and 7 were decided against both the plaintiff and the defendant. And the suit was ultimately dismissed. So far as the learned first appellate court is concerned, the appellate court made the following points for determination. The learned first appellate court first took up point number 3. And recorded that and after considering the materials on record, held that ample opportunity was given by Nunulal Yadav to his sons to purchase the property, but they did not respond. Whereafter, he exercised his right to dispose of the property and sold the said property to the plaintiff. Thus, Nunulal Yadav did not violate any of the conditions enshrined in Exhibit 3, Family Settlement Deed. The learned court also recorded that the learned trial court observed that the learned trial court held in paragraph 10 of the judgment that the transfer of the property described in Schedule A of the plaint by Nunulal Yadav in favor of the plaintiff was in violation of terms and conditions of the family settlement deed, and held that the plaintiff had no right, title or interest over the suit property. The learned appellate court recorded that the finding of the learned trial court in para 10 of the judgment are perverse and erroneous finding, and recorded that and held that Nunulal Yadav had completed and adhered to the terms and conditions of the family settlement. The learned first appellate court proceeded to discuss with the findings of the learned first appellate court and ultimately held that and observed that any condition imposing absolute restraint on the power of the owner to transfer any immovable property is not a valid condition. And in such cases, the deed is valid and the condition is void. But the learned trial court ignored these aspects and illegally and erroneously came to a finding that the sale deed executed in favor of the plaintiff was executed in violation of the terms and conditions of the family settlement, and held that the Exhibit 1, the sale deed executed in favor of the plaintiff by Nunulal Yadav in the year 1991, was not a legal document. The learned trial court ultimately, after discussing all the materials on record, also observed that the sale deed executed in favor of the defendant by Nunulal Yadav of the year 1994 with respect to the same property was previously sold by him in favor of the plaintiff in the year 1991 by the Exhibit 1, and that Nunulal Yadav had no right, title or interest over 71 square feet of land mentioned in Exhibit A on 27/1/1994, and therefore he was not entitled to transfer this property in favor of the defendant. The learned trial court ultimately held as follows. यहाँ से quote करना है. Page number 16. While deciding the point number 2, the learned first appellate court held that the defendant pleaded in paragraph 6 of the written statement that no consideration money was paid by the plaintiff to Nunu Lal Yadav, and fraud was alleged. The learned first appellate court has discussed the findings of the learned trial court and observed that Exhibit 1 is a registered document, and there is presumption that any document which is registered in accordance with law is genuine and legitimate document unless and until it is proved and established that the state document is not genuine and legitimate. Exhibit 1 contains the fact that sum of rupees 5,000 was advanced by Nunu Lal Yadav to Nunu Lal Yadav out of Sridhan, and mere pleading and statement of the defendant that no consideration money was paid cannot be relied upon in view of the legal presumption regarding the registered document unless otherwise is proved. The learned first appellate court also recorded that there was no subject matter for the defendant to cross-examine, which has caused any prejudice to the defendant, and accordingly the examination of power of attorney of the plaintiff before the learned trial court was not in contravention of any law laid down by the courts. The learned first appellate court ultimately held as follows. Para 18. While deciding the point number 1, the learned trial court held that the plaintiff has got right, title, interest and possession over the suit property, and the defendant was liable to be permanently injuncted from interfering with the possession of the suit property. And also held that the learned trial court erroneously came to a finding that the plaintiff could not prove her case while dismissing the suit. The learned first appellate court has discussed the materials on record while coming to their aforesaid finding and holding that the learned trial court had come to erroneous findings. This court finds that the learned first appellate court has rightly considered that the learned trial court had erred in drawing adverse inference on account of non-examination of the plaintiff in the suit, and her examination of her power of attorney, who was none less than her husband. The learned first appellate court has considered the presumption attached in connection with the registered sale deed and also the case of the defendant that the deed was fraudulent and was of the view that it was for the defendant to prove the allegation of fraud. This court is of the view that the learned First Appellate Court has rightly scrutinized the materials on record and has come to a finding that no adverse inference could have been drawn on account of non-examination of the plaintiff. And that nothing was required to be cross-examined from the plaintiff with respect to her personal knowledge once the deed was registered and the consideration amount was shown to have been paid. In view of the aforesaid findings, this court is of the view that the first substantial question of law is fit to be answered against the appellant and in favor of the respondent. So far as the second substantial question of law is concerned, this court finds that the learned First Appellate Court has framed the point of determination, and while considering each point of determination, the learned First Appellate Court has thoroughly discussed the findings recorded by the learned trial court and the reasons given by the learned trial court. And accordingly, this court is of the view that the second substantial question of law is also fit to be decided against the appellant and in favor of the respondent. In view of the fact that both the substantial question of law stands decided against the appellant and in favor of the respondent, this second appeal is hereby dismissed. ये एक तो जजमेंट आप दिए थे, हम इसको डील कर लेंगे. He has relied upon a judgment reported in. बहुत बढ़िया जजमेंट है, जबरदस्ती वाला आप सब्सटेंशियल क्वेश्चन ऑफ लॉ में बात. 90 bracket 1999 bracket close 3 SCC 573 paragraph number 15.
ये अपिलाट की तरफ से
अपिलाट सभी चीज तो लिखा है, कुछ छोड़ा कहाँ है? He has written everything. Presumption को डील किया. हाँ?
फर्स्ट अपील कोर्ट का जजमेंट.
हाँ, अच्छा से लिखा है.
इन द लॉ स्टूडेंट नोट आई मस्ट से.
हाँ?
नहीं, बढ़िया जजमेंट है.
हाँ,
फर्स्ट अपील. अब क्योंकि हम लोग पास आता है, हम लोग को तो बहस करनी है.
हाँ, तो आप लोग को बहस करना, हम लोग को डिसाइड करना.
जी.
यही काम. चलो.
Item 11 WPC 5715 of 2018 along with item 12 to 17.
सर्कुलर फाइल करने के लिए फाइल हो पाया.
क्या चीज के लिए?
एक सर्कुलर डॉक्यूमेंट लाना था.
हाँ, क्या कर रहे हैं? Counsel for the respondent seeks adjournment for 4 weeks. कितना टाइम चाहिए? बाय वे ऑफ लास्ट इंटेलिजेंस करके सोच लीजिए ना आप अपने रिस्पोंडेंट आपको. यस भाई, आप ना इस तरह से नहीं बोल सकते हैं कि कर दीजिए बाय वे ऑफ लास्ट इंटेलिजेंस. आपका एफिडेविट फाइल, यू आर एन अथॉरिटी. आप इस तरह से कैसे कर सकते हैं? यू हैव टू फाइल एन एफिडेविट. है कि नहीं है? आपके नहीं फाइल करने का कोई बेनिफिट तो आप पिटिशनर को नहीं मिल सकता है ना. यू हैव टू फाइल एन एफिडेविट. बाय डिफॉल्ट कोई रिट पिटिशन अलाउ होता है क्या? तो फिर
फाइल करना है, फाइल करने के लिए होता है.
इंस्ट्रक्शन मिला है.
इंस्ट्रक्शन
आपको लिख के बता देते हैं।
कौन किसने इंस्ट्रक्शन दिया?
माय सीनियर
सीनियर ने नहीं, कौन से रिस्पॉन्डेंट नंबर?
224
सबने आपको इंस्ट्रक्शन दे दिया है।
224 म्युनिसिपल कॉर्पोरेशन है।
The learned counsel appearing on behalf of respondent number 224 on instructions raised for 4 weeks time to file an affidavit in terms of order dated 14/7/2025. Counsel for the petitioner has no objection to the prayer for adjournment. LPA में क्या हो रहा है? पेंडिंग पड़ा हुआ है। उसको आप मेंशन भी नहीं करते।
तो वो लोग मेंशन करेंगे, मतलब हम लोग तो उसमें डिफेंडिंग इसमें है।
तो आपको कोई मना किया मेंशन करने के लिए?
मना ऐसा कुछ नहीं है।
Okay. Post on 30th October.
Item 18, second appeal 325 of 2019.
What is the substantial question of law?
We should just mention that in this case we are appealing for respondent 2, 3 and 11.
Time नहीं मिलेगा।
It's
not
not
last one.
and respondent 10 has died after this case. As per the office.
The learned counsel for the respondent number 2, 3 and 11
Yes, sir.
has submitted that as per the office note, the notice has been served to all the respondents either through themselves or through their close relation, but so far as respondent number 10 is concerned, he is dead.
Your worship, respondent 8 also has been served.
He is also dead.
No, it's only in the unserved incomplete address.
Acha. And respondent number 8 has remained unserved on account of incomplete address. You are for the landlord or tenant?
Your petition is worship.
किससे पूछेंगे?
Sira will have actually is on hearing code number 3.
So you do not know you are appearing for the landlord or the tenant. आप किसकी तरफ से landlord की tenant? Sorry? So you are for the landlord or the tenant? बिना ब्रीफ के खड़े हैं। आपने और मुंशी में क्या फर्क? Where is the brief? He has gone with the brief also. Respondent number 8 and 10 are your relatives.
Not very sure. We have no knowledge of as such, but as per
Who is respondent number 10? What's her name? None will be sure about that. And it has been reported that respondent number 10 had expired around 5 to 6 years ago. Apparently, the appeal has abated as against respondent number 10. Counsel for the aforesaid respondents has submitted that respondent number 8 has also expired.
it is not expired already, it's unserved in address.
अच्छा ठीक उसका डेट नहीं पता.
As per our knowledge, an office report.
Counsel for the appellant is directed to take fresh steps for service of notice upon respondent number 8 at his present and correct address within a period of 2 weeks, failing which this appeal shall stand dismissed as against respondent number 8. Post this case on through speed post, office to track speed post delivery. Post this case on 22nd September.
Item 19, second appeal 190 of 2022.
as per the last order, we have already filed the written notes of argument. In this case, Mr. Amal Kumar Shinha is to argue.
Who's for the respondent? As per the office note, the notice through ordinary process has been served upon the respondent number 127 through their brother, respondent number 4. In view of the fact that notice has been served through close relation, the notice has been served either personally or through close relation. The service of notice upon respondent number 1 to 7 is पहले भी तो वैलिड कर दिए ना, पहले भी वैलिड किया, पिछली बार कौन एक्टिव हुए थे? आतिफ अनवर. Mr. Atif Anwar had appeared on the last date.
On behalf of the appellants,
आज फाइनल डिस्पोजल पे हैं, हम इसको एडजर्न नहीं करेंगे. आप ऐसे
मैं जिससे कल के लिए
नहीं करते तो नहीं रखेंगे, कल के लिए नहीं रखेंगे. You argue with this. Start your argument.
been admitted on two substantive questions. First order was 6/2/2025 and subsequently
Six to 25. Subsequently,
order dated 18/6/2025.
read both the substantial question. Read both the orders.
Yes, sir. May I read the substantial question?
Yes.
The first one is whether both the learned courts below erred in not considering that when the defendants have admitted the said deed executed by Gunadhar Ghosh in favor of plaintiffs and further admitted that original lawyer Jagannath Napit and his son Gopal Napit had sold some plot of land to Gunadhar Ghosh and further came with a defense that Gunadhar Ghosh did not have possession of 9 decimal of land, rather only 6.5 decimal, then ownership proving such facts was with the defendant.
And further,
The second one is whether both the learned courts erred in not considering the admitted case of defendant that Gunadhar Ghosh was left with 13 decimal of land out of his total 19.5 decimals after he had sold 6.5 decimal of land to defendants, and further when plaintiff proved their possession over 9 decimals of land purchased from Gunadhar Ghosh by way of registered sale deed, mutation and rent receipts Plaintiffs were successful in proving their right, title and interest over the same. There is an IA also in order for additional evidence I have filed to be discussed.
What additional evidence?
There was sale deed which was executed by my vendor in my favor. I pray that this may be taken kept on record and
Where is that idea?
ID number 11242.
11242.
11,040.
When did you file that?
It was filed last.
Sorry?
The 19th of August.
After the last order?
Yes, Lord.
What is it that you want to bring on record?
The sale deed which was executed in favor of my vendor by the original vendor. Both the parties admit, the defendant and plaintiffs admit, that my vendor had altogether 19.5 decimals of land. Out of which defendant purchased 6.5 decimals of land, I purchased 9 decimals of land.
Then why do you need this?
When I first appellate court has rejected.
You have filed the additional evidence.
Additional evidence for additional.
Photocopy.
No, original I have annexed along with the photocopy. In the IA I have annexed the photocopy, but along with that there is a list of documents I have filed the certified. Because IA will be disposed of, and if this original has to be taken on record, then this will be marked and exhibit if at all it is allowed.
This is registered deed of the year?
1973.
Why didn't you file it earlier? Is there any explanation for not filing it?
During trial it could not be brought on record. Thereafter I stated
So
that.
why was it? Even in the first appellate stage?
No, first appellate state it was filed, it was rejected. The appellants approached this honorable court in WBC. During the pendency of the writ, the first appeal was dismissed. So it became effective.
So that order was rejected, no?
Order was rejected.
So
that was against the order of the honorable Supreme Court, which says that any additional application for additional evidence has to.
But that order has become final.
Has to be decided at.
That order has become final.
Final, but we had challenged that order before this honorable. And during pendency of that writ application, the appeal was decided. So it could not be.
That's your problem, no? You don't take care of the cases you have filed. When did you file your petition? The order particular rule 11?
Before the first appeal, that was.
And what is the date of judgment of the first appeal? And where is the order of rejection?
Yes. The civil appeal was decided on 21st July 2022. What is Annexure 3 with the IA, page number 26.
Why this sale deed is being sought to be brought on record?
Because this will prove my title. It is not in dispute that my vendor had 19.5 decimil of land. The contention of the defendant was that my vendor only had 6.5 decimil of land remaining, so he could not have executed a sale deed of 9 decimils. This is the sale deed by which my vendor purchased 9 decimals of land from the original buyer, which subsequently he transferred to me. So this I got it. Name on record.
So why? How is it relevant?
No, because the learned first appellate court has also rejected my
No.
dismissal.
How is it relevant? Just explain. How is it relevant? What is
Because
the
my-
relevance of this document?
My title, my vendor's title is there, and
Your vendor's title is not in dispute.
that is not in this.
Then
The area is being disputed.
that's right. Then why do you need this?
Just to show that the 9 decimal of
You
land-
don't. You see, this document you did not file it, right? So your due diligence is completely missing, right? Now you have to satisfy the court that the court needs this document to pronounce on judgment, isn't it? You explain why do I need this to pronounce on the judgment and decide the substantial question of law already framed. Yes. Why do
Because
this
may I
court?
just say that it may be taken on record if your lordship is
No, I'm just asking you. I'm hearing it. I'm hearing your second appeal finally. I want to know from you what is the relevance of this document before I even call upon them to respond to this argument.
My contention is only this much, Lordship, that their contention is only that my vendor was only left with 6.5 decimals of land. I just wanted to show that no, my vendor was actually having purchased 9 decimals of land, which was transferred. Only for that purpose.
No, you explain it. Your vendor, according to you, had how much land?
19.5 decimals.
19.5 decimals. How did he acquire this 19.5 decimals?
No, admitted case is 19.5. My case is that he was actually having 21 decimals of land. But admitted case is that 91 decimals.
Okay.
First contention is that he purchased 13 decimals of land from the original vendor.
Just 13 decimals from original buyer
And his
sons and
subsequently he purchased 9 decimals of land.
13 plus 9 is
20.
21. 9 decimal from
That also from the original.
original buyer. So according to you, he was having 21 decimal.
21. So 22 decimals.
13 plus 9 is 20.
20.
Okay, 22 decimal. Okay. How much did he sell?
He sold 9 decimals to me.
9 decimal to appellant. Appellant.
6.5 to the defendant.
6.5 to the कितना हुआ 13 and 9 and 6 is 15.5. So why do I need this sale deed?
So even after, that is what our case is and substantial question of law is based on that. That defendant came with the case that my vendor did not have more than 6.5 decimals of land, but they could not prove it. So our contention is that when it is admitted case of both the parties that at least 19.5 decimals of land was there with my vendor, out of which 6.5 decimals was sold to the defendant. Thereafter, he was remaining 13 decimals of
If
land.
it is an admitted fact that he had 19.5 decimal of land, why do you need this sale deed by way of additional evidence?
Just to fortify my claim that
ऐसा fortify करना नहीं होता ना. You have to show me that I need this document to decide the case. Rather than to be instituted. You are the defendant?
I was the plaintiff.
You are the plaintiff. You are still not able to explain as to why do I need this document to decide the case? Why at all do I need it?
Because the area has been disputed by the defendants. Area, we are claiming that we are having right title interest over 9 decimals of land. They are only stating that my vendor did not have more than 6.5 decimals of land available, so he could not have sold and put us in position for more than 6.5 decimals.
And this is the same.
What do you have to say to this additional evidence?
So far as this petition is concerned, we have objected to it by filing a reply also. We say
You have
that
filed a reply to this?
yes.
That's all. but तो कोई बात ही नहीं फिर तो हम देखेंगे क्या करना है इसमें. आपने reply is it forged?
No, we are not saying so. The admitted position is that the prayer was rejected by the learned first appellate court.
That's right.
And that was rejected. And the reasoning in the order of the learned first appellate court, if it is kindly seen, page 28 of their IA. I'm just reading it, the concluding portion. On perusal of the case report, it transpires that after filing of this appeal, the appellants could trace out the volume of the said deed and they have obtained a certified copy. And they have not filed any document regarding the sale of 62 decimals of plot in different persons in the trial court. And the learned court below found that plaintiffs have not been able to prove that the sale deed dated 6/6/92, that is our sale deed, is a false fabricated, same as they were acted upon. And also to not prove that the plaintiffs have got right title interest over the land by sale deed dated 10/11/82. So issue number 7 and 8 were decided negatively against plaintiff. The suit of plaintiff was also dismissed on contest. It also transpires that the documents filed on behalf of the appellant plaintiffs with their petition in serial 1 to 7 are concerned to only 49 decimals of plot 259, which were sold by the original owner and his son Gopal Napi through registered credits. But no any sale deed regarding said 13 decimals of said plot filed by them, which were alleged to be executed by said Gopal Napi. In the above facts and circumstances, I am of the view that appellant plaintiff cannot fill up lacuna. This is the basic reasoning. Cannot fill up lacuna in this appeal by additional evidence, which was in full knowledge of them in initial stage of the suit in trial court, where they were plaintiffs. And this is the basic reasoning. After discussing briefly the case, that they are trying to fill up something which is missing and which they have not done even in the suit.
Is it beyond the pleadings?
There is a pleading with regard to that sale deed. There is a pleading. That is there.
But this order has attained finality. This order was passed long back on 29 May 2013. And now even before this Honorable Court, in the entire memo, none of the proposed substantial question of law relates to this part. It relates to rejection of their application for Order 41 Rule 27, because that could have also been a substantial question of law as to whether the learned First Appellate Court has committed an error giving rise to a substantial question of law for consideration.
That's right. Anyways, you argue the case on merit. And if whatever you have to refer to this substantial question of law, you can refer, but you argue the case on merits. We have seen both the substantial questions of law.
Yes, sure.
Now you refer to the judgment and whatever the manner in which you want to argue.
So the suit was instituted for seeking two players. Firstly, our case was that our cell deed was executed in the year 1982. Till that point of time, the original riots, out of 64 decimals of land, had already sold 62 decimals of land.
You just read the initial portion of the trial court judgment. We'll find out what was the case of the respective parties, the issues framed, and straight away to the findings, right, of the trial court. Let us see what was the suit for
Page
from the
number
trial
10.
court judgment.
Page number 10.
Page number 10. Yes.
The present suit has been filed by the plaintiff against the defendant for that the suit land is the purchased land of the plaintiff's mother, and the plaintiffs have got a right title interest over the same. For confirmation of possession and in the alternative, plaintiffs are found to be dispossessed, then for recovery of past possession. For a declaration that cell deed number 2813 dated 6/6/92 is nothing but a false and fabricated fake deed, and same was never acted upon, and the same is fraudulent, and the same is not binding against the plaintiff and anybody else, since there was no existence of land of the said area mentioned in the deed for permanent injunction restraining the defendant to disturb the plaintiff's suit land area for the cost of the suit, for any other relief or release for which plaintiffs are found to be indicted. It is stated in the plaint that plaintiffs and defendants are resident of village Balrampur, BOPS Gamaria, district Saraikela. It is further stated that the suit land is at Moja Balrampur, PS Gamaria, Khata number 20, plot number 259, portion which is more fully described in Schedule B of the plaint in detail. It is further stated that the suit land is part and parcel of plot number 259. In fact, Srimati Saraswati Devi, wife of Dipti Singh, purchased the portion of plot number 259, measuring an area of 0.09 from Khata number 20 from Rayat and previous purchaser Gunandhar Ghosh, son of Gatti Ghosh of Balrampur, PS Gamaria, by virtue of registered cell deed number 4080 dated 10/11/1982. On payment of adequate consideration amount and got the possession of 9 decimals of land from the said vendor. It is further stated that Srimati Saraswati Devi enjoyed and possessed the said land on her Raiti right, and in mutation case number 280 of 1987-88, the circle officer mutated her name after thorough inquiry and finding her possession in the purchased land. It is further submitted that original owner Jagannath Napik, with respect to the land of Khata number 20 of Moja Balrampur, was absolute owner of plot number 259, considering an area of 0.64 decimal, plot number 258, area 0.68 decimal. It is also submitted that Jagannath Napik sold out the land of plot number 259 to Badnath Mandal by registered cell deed number 6064 dated such and such, measuring an area of 11 decimal. Jagannath Napik again sold land to Sri R.C. Sharma by cell deed number such and such, having area 9 decimal. Again Jagannath Napik sold to Gunadhar Ghosh by registered cell deed number 165 dated 9/1/1973 at measuring an area 0.9 decimal. And after the death of Jagannath Napik, his son Gopal Napik sold to R.K. Singh by registered cell deed number such and such, measuring an area 0.07 decimal, and said Gopal Napik again sold land to Darshan Singh by registered cell deed number 3892 dated 22/4/74, measuring area 0.05 decimal, and again Gopal Napit sold land to Ashwini Ghosh by cell deed number 8918 dated 10/9/74, measuring an area of 0.6 decimal. Then Gopal Napit sold land to Gunadhar Ghosh by registered cell deed number 132 dated 31/5/75 of area 0.13 decimal, and Gopal Napit also sold land to Sri R.C. Sharma by registered cell deed numbers such and such, measuring an area 0.02 decimal. So it is stated that by different cell from plot number 259 only, the sold area is 0.62 decimal of the total area of 0.64 decimal. So rest property remained 0.2 decimal after the aforesaid sales since 1971 to 1975. It is further stated that late Saraswati Devi, mother of both the plaintiffs, purchased the land from Gunadhar Ghosh, who purchased an area of 0.909 decimal by virtue of cell deed number 165 dated 9/1/75 on payment of adequate consideration amount, and got delivery of possession by virtue of registered cell deed as stated above. It is further stated that plaintiff's mother and father, after purchase, has constructed a building on the northern portion of the purchased land and given boundary on the western side and southern side of the and on eastern part of her purchased land is lying vacant with future plans. It is further stated that the plaintiff's mother and father in the year 1983 dug a well on northeast part of the pending portion, and they have been using the same as for gardening. But the boundary wall of the eastern part could not be completed due to bad financial condition, and unfortunately the mother of the plaintiff, Saraswati Devi, expired on 10/4/2003, leaving behind her two sons who are the plaintiffs in this case. It is further stated that plaintiffs have inherited and succeeded to the suit land and property by way of inheritance and succession, and they have been coming in uninterrupted continuous possession of the total purchased land of an area 0.9 decimal, including house and bounded part of the eastern side of open land, and the defendant, without any rhyme and reason, unnecessarily caused to file proceeding under section 144 CRPC by miss case number 168 of 2009, so that a false allegation that defendant purchased 0.07 half decimals of land out of khata number 20 plot number 259, which could not be at all accepted. It is also stated that till 31/5/75 out of total area of 0.64 decimal of land, 0.62 decimal of land have already been transferred to different portions by different cell deed, and only 0.02 decimal remained unsold. And Jagannath Napit had residential house over it, where he lived till his death, and after his death, his son Gopal Napit, and after the death of Gopal Napit, his wife and son are continuously living in the said 0.2 decimal of land as residential house uninterruptedly. It is further stated that Mohan Jaiswal was purchaser of 0.6.5 decimals of land in the year 1976 in plot number 259, and he has been claiming from Gunadhar Ghosh. Further, peculiarly again he managed another cell deed in his favor, claiming purchase of 0.7 half decimals of land and decimal in the year 1992, while cell deed number 2813 dated 6/6/92, measuring an area of 0.07 and half decimals. It is further stated that after purchasing of 0.06 and half decimals of land by Mohan Jaiswal from Gunadhar Ghosh, it is well possible because Gunadhar Ghosh once purchased 0.09 decimal land by cell deed number 165 dated 9/1/73 in plot number 259, and again Gunadhar purchased land measuring 0.13 decimal of land from Gopal Napit by cell deed number 132 dated 31/5/75. So defendant by such purchase acquired 6
So
and half.
Gopal Napit is the original owner.
Original.
The defendant purchased 13 decimal from Gopal Napit.
No, Gunadhar Ghosh purchased.
No, sorry, Gunadhar Ghosh purchased 13 decimal from Gopal Napit.
From Gopal.
Over and above this 0.09 decimal.
Yes, Lord.
Just a moment, read this line. It is further stated that after purchasing 6.5 decimal of land
by Mohan Jaswal, the defendant.
By Mohan from Gunadhar
From
Ghosh.
Gunadhar Ghosh, my.
It is well possible because Gunadhar Ghosh once purchased
0.09 decimal land by sale deed numbers 165 dated 9/1/73, lot number 259, and again Gunadhar Ghosh purchased land measuring 0.13 decimal of land from Gopal. So our contention was that it is quite possible that he has purchased 6.5 decimal of land from my vendor because he had 13 and 9 decimals of land.
कल कंटिन्यू करेंगे सेकेंड हाफ में तो दूसरा ही सेकेंड अपील नंबर 190 ऑफ 2020 हियरिंग हैज commenced post the take of further hearing 10:30 first case कहाँ है इसका ठीक से चार्ट बना के लाएंगे सेल डीड नंबर
We have given the chart in our written statement in tabular form. The sale deeds, entire sale deeds as narrated by the complaint and as narrated by the
और ये जो आपने सेल डीड फाइल किया है ये सेल डीड नंबर क्या है डेट क्या है कौन इसका वेंडर है कौन इसका परचेसर है और कितना एरिया
ठीक